Well, hello everyone, and welcome to this Old Square Tax Chambers talk on tax litigation. Hopefully everyone can hear me. If anyone can't, do raise your hands. We're joined as well by various people on Zoom. Apologies to the Zoom joiners for the late start. So tax litigation, I think it's fair to say, is a fairly broad topic which raises lots of different issues. People approach it in different ways, even among the five of us, and have different aims from it. So in approaching this talk on tax litigation, we're going to try something which is a little bit different from our usual seminars. We're going to effectively approach it as a single talk, with each of us broadly taking the lead on different points, and hopefully piping in with different comments to reflect our different experiences and different views on matters, which will hopefully all be interesting and helpful to all of you. Related to that, as we do go along, do feel free to raise a hand if you've got a question that you'd like to raise. We'll also take questions at the end, and certainly for those on Zoom, if you want to send in any questions, and we'll try and deal with those as best we can when we get to the end. So with that, if I could just introduce the speakers going down. This is Ross Birkbeck, Harriet Brown, Rebecca Sheldon, and Chris Vallis at the end. And we've all got experience of engaging in tax litigation, and hopefully we'll all be able to share that with you today. So the first topic that I want to talk on, and I just want to check, where are we with these slides? They don't seem to be. Here we go. Excellent. No, not changing. There we go. First topic, why go to the tribunal? And that's what I want to address at the outset, is this basic question: why do we bother going to the tribunal? And I think there's an important point in there in the evolving approach of the revenue to dealing with tax disputes. A big change, which I certainly have noticed in recent years, has been in that approach. When I started in practice, and for quite a significant period of time, it was actually quite rare for tax disputes to get anywhere near the tribunal, and that tended to be because the revenue were sensible, taxpayers were sensible. If taxpayers were well advised, then there were broadly one of two outcomes: either you reached sort of a sensible, satisfactory conclusion, or you realised that, well, actually, this is going to lose. We're just going to have to accept the position. There may have been the odd differences, and there remain cases, I suppose, where people want to go to the litigation because it's the only option they have, and they're not left with much other choice. But in the main, certainly for sort of well-advised taxpayers, that seemed to be the sort of general pattern of things. A change which I've noticed, and I think other people have noticed in recent years, has been a huge increase in the difficulty of trying to reach a sensible outcome with some revenue inspectors. And there are cases where it's just not been possible to reach any sort of resolution. And very often, despite the taxpayer having a strong case and being right, I've seen cases of officers taking some very extreme positions where they're insisting on double, and even, I think in one case, triple taxation in relation to a transaction, which is clearly and obviously wrong, but trying to explain and trying to get someone to back down off that position has become, certainly in my experience, in some cases, and in a lot of cases, a very, very difficult exercise. And it's not something which tends to be possible anymore in the inquiry stage in the way in which it once was. Now, why that is the case, I think it's probably open to question. I think I've heard lots of different views as to why it might be. We all remember HMRC got a kicking for reaching a settlement with Goldman Sachs. They got judicially reviewed for that. I think one view is that as a result, institutionally, they're nervous of agreeing to let anyone off tax which someone has thought might be due. It might be that there's simply just nowadays more pressure to raise and collect taxes, We've seen in the election that every party thinks that there's billions and billions of pounds to be had from stopping tax avoidance, and different views arise as to what's tax avoidance. And another view I've heard is that it may be just the influence of customs following the merger with the Inland Revenue, and a suggestion that they take a slightly more robust and thuggish, shall we say, approach to enforcing tax liabilities. Be that as it may, we are in the situation we're in.
Rory, can I just ask a question?
Yes, sorry.
To what extent do you think the success rate of HMRC, particularly in, say, the First-Tier Tribunal, has an impact on how willing they are to push litigation forward?
Well, I think there's certainly sort of one sees it said sometimes that, well, actually the tax tribunals are always going to fine for the revenue, so there's no point going there. I don't, as it happens, think that's the case. I think you might say that there's some judges who are sort of easily impressed by revenue arguments, but for the most part, I think the judges are fair and honest and trying to reach an outcome which reflects the legislation. And so when you do face the position of the revenue inspector having taken an extreme approach, it's not something which you would normally expect a tribunal to sit behind. Whether the inspector thinks that the tribunal might sit behind it or not, I don't know. I suspect it's not because of the view that they're going to win in the tribunal. It's just that not an awful lot of thought has been put to it. I've certainly seen cases where there's been very thoughtful, very clear, very erudite arguments setting out why there isn't a tax liability arising, and it's just been sort of brushed as a by the by, and it does seem that getting listened to, having a serious conversation is very difficult. And it's in that context, I think, that tax litigation has adopted an evolving role, because whereas previously you might have gone to the tax tribunal with a view to going to an actual hearing and getting a decision at the end of that hearing, I think one effect of the changing rule is that nowadays it's quite important to consider the tax tribunal in the context of the dispute as a whole, and the benefits of going to the tax tribunal, even knowing that, well, actually we might not want to spend the money fighting a case over 4 or 5 days. One of the big benefits is that when something's notified to the tribunal, an officer of the revenue, which won't necessarily be the investigating officer, has to come up with a statement of case. That means they have to decide what their case is. And I've seen quite a few cases where in that circumstance, in that situation, obviously there's been a discussion behind the scenes, and this is something which I think Chris is going to speak to later, where the decision's been made, actually, we don't have much of a case here, and simply the benefit of having somebody else look at the case means that what was going back and forth for quite a period of time gets resolved. And so within, I think that is an important role of the tax tribunals and tax litigation in sorting out issues. HMRC also do have to be alive to cost issues. There's a no-cost regime, but it's subject to reasonableness. And if you're pursuing a completely hopeless case, there have been cases where the tribunals have gone, well, actually, we will award costs in those circumstances. And again, someone will talk about that, so I won't get into it too much. And another point is that very often in these discussions, it's, well, you don't have the evidence for that, and something can be set out very clearly in a letter, and it's going, well, there is no evidence for that. Effectively, what is being said is what the taxpayer or an employee of the taxpayer has been telling the advisor. When that is set out in a witness statement, it's no longer an answer to go, well, you don't have evidence for that. You have something which is set out clearly. And again, that has to be considered by somebody with the ultimate sanction of a hearing in front of an independent tribunal at the end of it. And as I say, it is an independent tribunal, and it is a tribunal which will fine for taxpayers and does fine for taxpayers, particularly in these, what I might call, unreasonable situations where the revenue are pushing a position which, frankly, is wrong and is unreasonable. You may get different situations, and there are different cases. Tribunals will be a lot less sympathetic where there's a whiff of tax avoidance involved than they will be where it's a straightforward commercial transaction and something seems to be going wrong because there's a huge amount of tax which has been sought to be gathered out of it. And so you have to consider all of that in context. But I suppose the overarching point as to why go to tribunal is that I think nowadays, within the context of disputes with the revenue, it forms a much more important role than perhaps it did previously. And as part of that, and hopefully this was something which will get into in the course of the talk today, it's important to understand what is going to a tribunal involve, how to go about doing it, and how to get the best chance of success, whether that is before actually reaching the doors of the tribunal or once you're in front of a judge. So those are my sort of opening remarks. I will open it to any more comments from the rest of the panel before handing over to Ross. Does anybody have anything to add?
You do, I think I do.
I'm going to jump in anyway, so you go.
So all I would think I was going to, and it's not really an addition, I think it was maybe just one of the things that I find quite difficult explaining sometimes to certainly non-professional clients is that you will get a lay client in front of you and they say, well, HMRC wins, say, 85% of cases in the tribunal. What is the point? And you sort of have to say, well, look, it's not about the odds across everything. It's about how good your case is. So I think I wasn't trying to say it's the game's rigged, though sometimes it can feel that way. I think what I was saying was sometimes people don't see litigation as a viable strategy to resolve a dispute because, A, they think you're going to end up in court, which is absolutely not necessarily the case on day one, but also they tend to look at a general position rather than the position of their case. And I do sometimes find it quite hard to convince them to look at what their case is rather than just the statistics, which you see from year to year.
Do you have any sense of how many disappear reach their DT? The majority disappear?
I don't, but there may well be statistics on that somewhere.
I think Chris was going to talk about that. I think he's got some statistics in his notes.
Oh, fantastic.
Yeah, I mean, I think I can concur. I mean, it seems to me just there's three reasons cases go to the hit tribunal, either because the taxpayer's desperate and there's nothing else to do, last roll of the dice, or because there's an issue, and those are those cases very early on where it becomes apparent there's a single issue that the revenue disagree on. What was the value of the shares or the asset? Was the company trading? Is it R&D? And sometimes very early on that you just disagree on how that legislation applies, and you think, let's get to the tribunal as quickly as possible and have a judge decide, because that's the only way this is going to be resolved. And everything in the middle is just is bashing your heads together. The third one, which I think is what your point, Rory, is that as you go down the sort of road from the inquiry to the hearing, minds are focused. New minds are brought in to reassess the situation, and you can get clarity and you can resolve things amicably before you get to the judge.
Yeah, I think it's important to understand which type of case you are, because there are obviously cost implications for the client. And if it's a type of case which is absolutely going to have to fight, and it's just a straightforward difference of view, then a view has to be taken at the outset. Where I'm certainly seeing more cases and where I think it's more relevant is those sorts of cases where actually we don't really understand what the revenue case is, because they're advancing all sorts of things, and even just going to the stage of getting a statement of case in that sort of situation, so I can understand what the client can understand, this is what the case against you is, and take a proper view as to, well, at this point, do we want to advance or not, I think is quite important and quite helpful, not least because the costs of making a notification to the tribunal in order to get a statement of case really aren't very much. And so it ought to be something which is considered as a matter of course in those sorts of cases, even though you might then decide, well, we've seen what the case is, we think probably on balance it's not worth the cost of fighting it the whole way. But that's a lot more useful than having to make a decision at the point of a closure notice, which perhaps isn't as well reasoned as you'd hope it would be.
Yeah. Shall I, can I have the clicker and go back?
Good luck making it work.
Surely it works. Yeah, there we go. So, yes, so I'm going to look briefly at what's involved in taking a case to the tribunal. And broadly, I've set out here on the slide there the roadmap. It starts with the inquiry, which is, as you'll all know, is in many senses the sort of biggest and can be the longest running stage of a dispute with the HMRC. Harriet's going to look at this in a bit more detail next, so I won't steal all her thunder. But that ends with the assessment. If you've got a formal inquiry, you'll end with a closure notice. If you've got an informal inquiry, you'll end with a discovery assessment generally, if we're talking about the normal taxes. And I think the point is you may have had a lot of you may be litigating, in a sense, for quite a long time by the time you get to that assessment. You may even actually have been to the tribunal on information notices and that sort of thing. You may have had to go to the tribunal to get closure in the first place. So that first stage is quite significant, but in the scope of getting to the tribunal, it's really a pre-action stage. It's obviously when you hit the assessment, your tax liability for your client crystallizes. You've then got a tax liability to the revenue, and that starts the clock for the rest of the road, because you've got 30 days to appeal it to HMRC. Then you've got that you're going to be offered a review. You've got 30 days to accept that or not. The review will take 45 days. Then you've got 30 days. Does this have a mind of its own? Then you've got 30 days after you get your review conclusion to appeal to the tribunal, and then you're in the hands of the tribunal and directions from the judge. So that stage assessment kickstarts really the formal process. I think the thing to say about the review, the appeal to HMRC is obviously, well, firstly, it's very easy. Technically, the legislation says when you appeal to the HMRC, you have to give grounds, but not in most cases. In most cases, everybody already knows what the grounds are because you've been arguing about it for some time. So even if you just write a letter saying, I'm appealing your assessment or closure notice, the grounds will be implied and the revenue won't take that point. They'll accept your appeal in a one-word letter. Obviously, better to, in summary, set out exactly, again, why you disagree with their assessment. But it's a very simple process. And then we have the review machinery. Now, I don't know what your experience is. 99% of these don't change the outcome.
I was just thinking, I've never had a wholly successful review. I've maybe got some points narrowed down.
Yeah. And I increasingly think of the review as breathing space. Right? You've been through a long dispute in the inquiry. It's culminated with the assessment, and if you go for it just buys you a couple of months if everyone to just do nothing and think about how far they want to go with this. Because otherwise you're going to have to appeal to the tribunal straight away and kickstart that mechanism. So it can be, who knows, it might be successful, but normally they're not. And you'll come out the other side with the same answer, and you'll have to go to the tribunal. So this is the first time you have to set out your grounds formally in the appeal to the tribunal, and that's when you're going to really want to think about what is the case you're going to put to the tribunal in those grounds of appeal when you notify to the tribunal. That's going to be answered then by HMRC's statement of case. And as Rory says, that may well be the first time you genuinely understand what revenue are really getting on about. I mean, I have cases where up until then you don't know whether they're arguing you haven't provided the evidence to prove your case or whether your case is wrong on the fundamentals. And this is where they have to crystallize that. And after that, stage is set for the hearing. Discuss an argument, obviously, the last time that, because I think, Chris will correct me later if I'm wrong. I think the revenue barristers are often brought in either for the statement of case or for after the statement of case. So it might be that you get revenue solicitors introduce the statement of case and then a further independent barrister's review when you get to the skeleton phase. So these are all stages to narrow the arguments. And obviously, hopefully, by the time you've got to appealing to the tribunal, you really do know what the dispute is about and you can articulate it clearly, because that's going to minimize costs. Because what I've set out here is, of course, like an ideal situation. If you get to appeal and you don't know what the argument is about and you haven't got your evidence sorted, there could be all sorts of nonsense goes on between appealing to the tribunal and the hearing. Grounds to amend statements of case, grounds to admit late evidence, late appeal applications, all the type of stuff we love. But it's no use to anyone who's not a lawyer. So hopefully you've got everything in hand and you can proceed on to the hearing, where obviously, it could be many weeks or it could be just a day. So that's what's involved. The second thing I was going to touch on, unless anyone wants to jump in and add anything.
I was just going to say there seems to be a bit of an omission there between statement of case and skeleton arguments, which is evidence, which is
that's a fair point.
Very, very important, and is one of the stages at which the thing will be reviewed again as against what evidence is being provided.
Yeah.
So I think, but yeah.
Equally, I think Rebecca is going to talk about that in some detail.
Yeah.
The other thing I just wanted to mention, and again, it's really a management of expectations thing, is don't forget to do a postponement application,
Oh, yes.
because tax, obviously, it's due at the point that you get the assessment. If you don't postpone that tax or apply for postponement, HMRC can start collection processes. I have had a couple of sticky situations where they have got quite a long way down the road, one involving bailiffs before any action was taken about that, and it's stress, cost that wasn't needed. We ended up in an applications court trying to resolve that one before the High Court, as opposed to just dealing with it with an application to HMRC. So it's an expectation management thing, but also one of those essential things not to forget.
Yeah. Yeah, it's and it's again, it's a sort of one-word application, really, a one-line application in your appeal letter. Just say we also are apply to postpone.
And normally they do.
Yeah, they very rarely resist it. So the other aspect of what's involved is who's involved, and just just to think about at the outset what kind of team you've got, and who needs to be involved. I mean, the work I do certainly involves, sometimes it's literally just me and the client. Otherwise, you've got teams of tax advisors and accountants, solicitors, and further witnesses, all of whom need to play their part. So I think it's important to understand, obviously, you don't necessarily need solicitors to go to the tribunal. And it can be much more efficient not to do so. And also to consider, I mean, for example, sometimes you might want senior and junior counsel instead of a team of solicitors. So a junior counsel can do that role of organising evidence and bringing things together instead of having an additional solicitors team. But the other aspect of this I think is important is when everybody gets involved. Because the earlier the better, I think, in terms of knowing who's going to be coming on the journey with your appeal, the easier thing to manage. It's difficult for anyone, I think, to be brought in at a late stage and expected to know everything that's been going on. Or equally, sometimes you're instructed on a case and then you don't hear anything for 6 months, and then you're suddenly it's dropped back on you and expected to catch up. Much better to keep your team together in the loop as you push through the process. No? I've forgotten something else.
Absolutely.
I can see the way you're looking.
You have not forgotten anything. I completely agree with what you're saying there. And indeed, that I don't know if you're finished for now, but that dovetails nicely with, I think, the first point I'm going to make.
It's yours.
Thank you. So this might seem like a slightly odd way to couch this. When does the dispute start? But to me, this is all about mindset. Thinking about when the dispute starts is about how you approach the whole thing. And if you ultimately do end up in a tribunal, can massively alter your chances of success. Now, I know barristers have a completely undeserved reputation for being arrogant, but there are genuinely cases that you get where you look at it and you think, oh, this could have had such good legs, but now I've got my hands tied with evidence, I've got my hands tied with a statement of case, and what I can do to change this at the point that I've got it now is really difficult, and our chances have gone from here to here. And so I think that is really what I mean by when does the dispute start. And I've seen in practice a lot of professionals dealing with an inquiry like it isn't the start of a potential dispute, and thinking about it very much in this mindset of, if I just give HMRC everything they want, they will go away. Now, I think most of us probably know that almost never happens. If you give HMRC everything they want, what you tend to get is that they want a lot more stuff as well. So there are some issues around this, but for me, the dispute starts as soon as you know there may be an issue. As soon as you know there might be an issue, or you're in a process whereby it could end up being an issue, by which I mean a further assessment for tax. And so from that point, you want to be in litigation dispute mindset, because not only will, in my view, it improve your chances of success if you end up in tribunal. It will improve your chances of never getting to tribunal in the first place. Now, that isn't to say be very aggressive and refuse to provide things, but it does mean thinking about what you are doing. I forgot to check the proper quote, so I'm going to quote Homer Simpson instead. If you want peace, use knife. So it is a little bit, if you want peace, prepare for war. Now, you may say, well, HMRC have boundless information powers. What can I do when they ask for information? Well, their information powers are not boundless. HMRC, I think, sometimes do take the approach that because inquiry powers and the way that they are couched are very wide, that they do, that they can ask for anything and you have to give them it. My view is that HMRC's inquiry powers are not that wide because they are at the very least, limited by public law duties, for example. So when I mention that, HMRC shouldn't be asking you for things that are, if you've got an inquiry which is said to relate to a specific thing, they shouldn't be asking you for information that is irrelevant to that. Even more so, and I have seen this, where you get interrelated entities, so you might have an individual who's being inquired into in relation to a self-assessment, and they are, say, a director and majority shareholder in a company. You should not, my view is that HMRC should not be asking you for any information which is clearly only pertinent to the corporate tax of the company and not pertinent to the self-assessment return of the taxpayer. Now, you may say, well, that's axiomatic. I've seen it on a number of occasions that you are asked for information. You think, well, that's got absolutely nothing to do with this. Not only has it got nothing to do with what we started from, it's got nothing to do with the taxpayer they're inquiring into. I can see no relevance of that. So there are things that you can draw a line at and ask questions. And again, this doesn't mean being aggressive and saying, well, I'm not providing you with that. It means saying, we don't understand the relevance of this. Until we understand the relevance, we don't think it's prudent to provide it. Please, can you give us more information? Now, that can result in a back and forth, and you have to take that into account in assessing whether or not this is a good idea. But you can push back, and you can push back politely and in a way that is going to be helpful to your client. That's not to say there isn't a place for pushing back in a more forceful way, but this isn't it, in my view, again. And the other thing is, which is often missed, anything that's subject to litigation privilege. I've been looking at a case I have coming up soon today, and HMRC asked over and over and over again for legally privileged advice, and ultimately the accountants who were managing the matter at the time gave them it. It doesn't do anything too bad. It's not awful, but I would just have said, absolutely not under any circumstances may you have this advice. You are not entitled to it. It is privileged. But we are where we are. So it's things like that as well. You don't have to just hand everything over. There are limitations. The other one to watch out for in that respect, in that early stage, is when... I'm sorry, I'm just going to check what says on my next slide. Oh, golly. There we go, yes, it's still there. So the other thing to check is when you're looking at potential discovery assessments, HMRC are often asking for you to provide things informally. Now, you can do, it might be sensible to, but be aware that if they're asking you informally, you don't have to do that. You can push them to use their actual information powers. If they ask you to give your permission for them to get information from third parties, again, you don't have to. I'm not going to talk about the circumstances when you do and when you don't, when you should and when you shouldn't, because they're very fact dependent. But just because HMRC asks for something doesn't mean that you should give it to them. So just to go back here, the very latest point at which your dispute starts in terms of getting into dispute mindset is at the opening of the inquiry. That is the latest point that you want to start thinking about this maybe being an issue. Once you've got to the closure notice, as Ross has already pointed out, you might have been to court 3 or 4 times already. It's too late at that point to start thinking, oh golly, I'd better start preparing for actual litigation. This isn't to say that these steps aren't useful, But for me, one of the best things that a client can do to ensure a successful resolution of a dispute in court or outside of it is to start treating it as a dispute. And that doesn't mean treating it in an aggressive manner, but start thinking about it as a dispute. I don't know if anyone wants to weigh in on that.
Yeah, I think I'd sort of classify it, which is probably not different from what you're saying. Be cooperative, but be careful. At the end of the day, you want to make the issue go away. And the shortest way of getting the issue to go away is to get the revenue to agree that there is no issue. And if you can do that in correspondence by providing answers at an early point in time, then absolutely do so. But you do have to be careful as to what you're doing and what you're providing. A big one is stuff which is legally privileged, and the revenue do ask for it time and time again. But also be careful, even when there's a decision, well, actually, we do want to waive privilege in relation to this. A trick which I've seen sort of pulled out time and again is where some piece of privileged information is provided to the revenue, and they come back going, you've waived privilege in relation to this, you've waived privilege in relation to a whole screed of other things, and so we want to see all that now. And so I think that can be stopped by, again, just being careful. If you're going to waive privilege, just be very clear that it's been waived in relation to this one document and nothing else. And that can obviously help in putting a stop to something later on. Sorry, do you have a question?
What is the role of the HMRC questionnaire?
I was going to ask, what role does a questionnaire play in the timeline that you're considering? So I have a case where a client has received a questionnaire, and it's being dealt with by her accountant. Does that necessarily lead on to the opening of an inquiry?
It doesn't necessarily, but obviously that risks an inquiry. So treating it with caution and as the potential start of a dispute is, I think, hopefully will result in you being less likely to make a mistake, or what doesn't look like a mistake now, but sort of 2 years down the line looks like a very serious mistake, or even a smaller mistake. So yes, I think really when you start to engage about something and you can see, because you normally can see that there's a potential for disagreement, that's when you need to get into this dispute mindset. And as I think we've both said, be cooperative. There's absolutely no reason not to be. And that again helps you to resolve a dispute. But be aware that you might be in the process at the very early stages of resolving a dispute, as opposed to just sort of routine filing or something that is wholly cooperative, because it may not be. It might be, and that if it is fantastic. But yeah, I would say as soon as you see that there might be an issue, might lead to an inquiry, etc., that's when you start thinking, is this a dispute? What do I need to be doing? What do I need to be careful about?
So are you saying that an inquiry doesn't always start with a questionnaire, but a questionnaire can lead to an inquiry?
Yes.
Sorry, just to add one other thing, I think we're talking about being careful. That doesn't necessarily mean withholding information from the revenue. Where I think the problems can tend to arise a lot in not being careful is providing an answer just to try and get an answer off the desk, which isn't actually accurate. And then later on down the line, you're trying to explain, well, why was that answer not correct, or why was that answer not truthful? And that can cause difficulties in the course of the inquiry. So it's not providing the information, it's making sure that you provide accurate information which can be relied upon.
Because the responses to a question could end up being evidence.
Yes, but it also, if you're trying to persuade the revenue that, well, actually, this wasn't the case later on down the line, and your first response in a questionnaire contradicts that, it's quite difficult to persuade anyone on that.
And something else you can see is that where you're changing your mind or constantly developing a position, HMRC can really start to doubt everything and think, well, they're just trying to pull the wool over our eyes, which is understandable. That's a completely normal reaction to have. So you need to be confident that what you're saying is correct for all of those reasons.
I think it's one thing. It's often worth considering. You might be investing in a comprehensive legal opinion quite an early stage in a dispute like this. I mean, it's front-loading the cost, but what you often find that, if you've had full comprehensive legal advice of the issues that you might have between yourself and HMRC, if it finally gets to grounds of appeal and even the tribunal, a lot of the legal analysis is done. You've been able to narrow down your arguments very early on, and it means if you've got that analysis done thoroughly and well early on, your correspondence with evidence is going to be consistent and reliable. And it will also obviously map out the risks of as far as evidence goes and what's needed.
And having that cost at the start usually does reduce the cost as you go through. Because as you say, if your argument stays the same, if you know what your legal arguments are and what your factual position is, and that doesn't really change, then...
Best case scenario is it crystallises the issues and the argument early on, which then get resolved. Worst case scenario is it just reduces the cost of figuring out those arguments later because you've already got them to hand.
Exactly. I think we had another question over there. Can you just do your microphone and button, please? Thank you.
This one? Just a quick question. You mentioned about HMRC requesting things informally, and obviously you can force them to use their information powers instead. Anecdotally, and by that I mean there's quite a few articles on the internet from various advisors indicate that if you do that, so if you refuse to provide something informally and you insist on receiving an information notice, that could have an impact on the view that HMRC then take if tax is found to be due and they're considering the penalties position. Would you say that's true or untrue?
That's an interesting one. I don't have any personal experience of it having an impact. I don't know if anyone else does. Christopher, thank you.
Yeah, I definitely would say that if HMRC can make the point that you didn't make a prompted disclosure, then they will take that point. So the more cooperative you can be, the less likely it is that you're going to have a penalty where they're accusing you of not having given that information voluntarily. Yeah, definitely.
Although I did just want to pick up on something that Rory and Harriet had said. Obviously be cooperative and helpful, that's often a really good strategy, but don't be too helpful. Don't start giving them ideas that they didn't have. I think there's definitely a line between the two.
Who's next? Because I'm ready to hand over.
Thank you for clicking for me. Okay, yes, so witness evidence. Obviously, this is a very important stage. I've had at least one case where after we've put the evidence in, HMRC have withdrawn. So it can make the difference, and it often does make a massive difference where you have a dispute which is very focused on factual issues such as domicile. Just in terms of when this is likely to come in, so with directions from the FTT, generally this is going to come after you've got your list of documents that you're going to rely on and you've had it from the other side, and then you're going to have your witness statements. However, it's never too early to start thinking about preparing them, given how important they are to the process. Just as a preliminary point as well, the strict rules on evidence don't apply in the FTT, so evidence which wouldn't be accepted in a civil trial can be accepted by the FTT and relied on. Now, why is it so important? Well, as I'm sure you all know, the taxpayer generally has the burden of proof to the bounds of probabilities. This makes the quality of the witness statement really important. And as an example, so a case I was in, a taxpayer with James Kessler, there were limited contemporaneous documents available due to the passage of time and the nature of the issue. And so the written evidence was really very important, and it was some of the major evidence that we had to go on. When is it important to call a particular witness? Well, when they're going to be able to give material evidence. If you don't call someone and they are material, for example, you've got a company, you've got one director, and you don't call them and they were available, you are potentially at risk of adverse inferences being drawn. So that's important to note. And also, obviously, in that circumstance, I would be concerned about the burden of proof being met. And what does a witness statement do? Well, it's the evidence that usually stands as the evidence in chief. So rather than the old days where I believe you had to go through monotonously ask open questions. What you do is you have a statement that goes in, HMRC then cross-examine that statement, and then you can re-examine if necessary. I try to avoid it where possible because I think re-examination broadly makes things worse than better, but you can do that if you'd like. But the point of that is to ask clarificatory questions. It's not to have a sort of second crack at examination in chief. So what's the difference between factual evidence and expert evidence? So broadly, a factual witness gives evidence as to facts rather than opinions, whilst an expert witness gives evidence as to opinions rather than facts. So likely areas where this may come up in a tax context can be things like foreign law and quantum. So expert evidence tends to be needed when the court doesn't have the requisite specialist or technical knowledge, and you can't have it as a right, so you've got to apply for it under Rule 15. So one reasonably fun example where I had expert evidence was HMRC were disputing that the signature was signed by a particular person. So we had to get a handwriting expert in, comparing lots of samples to prove that it was the particular person. Now, the expert's duties to the court, even if they're instructed solely, so it doesn't matter that you're paying them, it doesn't mean you're going to get the answer that you want. But you can also have a single joint expert, and that can be quite helpful because it means that hopefully you're not going to be challenged too heavily on it, or at least not as heavily as if it's just your own expert. Do also, though, consider when you can just ask a judge to take judicial notice of something, because expert evidence can be quite expensive. So an example of that, I had a VAT rating case and I asked the judge to take judicial notice of the fact that men are generally bald more often than women. Didn't think I needed too much evidence for that. So what is a statement not for? Well, it's not for submissions on the law. And I reasonably regularly pick up HMRC officers on this, who go into some detail as to what they think the law should be. That's not the point of a factual statement. And it's also not for complaining about HMRC. And I know that it's a very stressful process and people feel it's cathartic to put a paragraph at the end about how horrendous this has all been. But it's not relevant, and actually I don't know what other people's views are of this when people do this, but I think it can detract from focusing on what the statement's going to do.
Honestly, for me, I try to get rid of it if I can, but if the client is too wedded to it, I just let it go.
Yeah. Yes, and so yes, so it's quite common, and I don't think it really probably makes a difference in most cases, but I also try to get it out of there where I can. Key points for preparing statements. Well, as I sort of intimated at the start of this, obviously they are incredibly important, so they've got to be thorough. Ideally, and this is very basic, they should be chronological, paragraph numbers, headings to assist with some coherence so the judge can look at it and sort of know where the narrative is going. It's got to be a witness's own words. So much as I often would quite like to just sit down and write it so it can meet my case, alas, you can't do that. What I tend to do, and I think that is the approach of most on the panel, though please chip in if not, I tend to ask a series of open questions and set out the structure. So they're not starting from a blank page, because if they start with a blank page, you are probably going to get nonsense back and it's going to take years. But hopefully then it's obviously still in their own words and it gives some sort of structure to it. One important thing to do is to identify if a source of information is not within the person's knowledge. There's usually a little paragraph at the start that says they're going to do that, but it's important not to forget. And the final thing that I just wanted to touch on before I sort of open it up a little, references to exhibits. So the documents which support what you're saying, they're absolutely vital. And obviously it supports what's being said in the witness statement, but it's going to help the judge again with that narrative. So it's really important that they are in there. So that was all I had on witness evidence. Anyone's got any further comments?
Yeah, just to reiterate that last point, I think you pointed on the fact that sometimes if a person doesn't give evidence, then adverse inferences are drawing. When, as is often the case, the facts took place over a very long time, ago, the taxpayer can be in a difficult position in that if they don't give evidence, then adverse inferences are drawn. If they do give evidence, then the submission's made, well, this is all very long ago, they clearly can't remember anything, so just ignore everything they've said, which neither of which is very helpful. But the key point is that where there are contemporaneous documents, it's really important to dig them out and to tie them into the witness statement so that if the witness is trying to say, well, on this occasion, this is what happened and this is why I did it, and you're never going to have an email between the witness and somebody else going, I'm going to do this for reasons X, Y, and Z. But very often there will be documents which tend to broadly support the narrative which they're putting forward. And if you can refer back to those and to add credibility to what's been said, that's incredibly important in terms of the weight which is going to be given to that evidence at the end of the day. So I think the witness statement and the document exercise do very much go hand in hand and do need to be dealt with together.
A separate point that I just think is important to remember is that amongst other oddities, such as as Rebecca pointed out, you have this position where the strict rules of evidence don't apply, so the tribunal can take notice of evidence that wouldn't be admissible in civil hearings, which I always find bizarre because basically that's just stuff that's irrelevant. And you think, why on earth would the tribunal want to look at stuff that's irrelevant? But anyway, one of the other oddities is that if you have standard disclosure in the First-Tier Tribunal, that is different to disclosure in the High Court. It is parties have to disclose what they intend to rely on. Now, I think this is potentially problematic in some circumstances because the taxpayer will likely already have disclosed absolute swathes of things to HMRC in the course of providing information. If they then say, well, actually, we're only going to rely on this 10% of it, HMRC can still rely on anything in the other 90% of it, but you may not be able to get access to, for example, what HMRC has done, the process behind it, why they have done it. This used to be quite important in discovery assessments, less so since the Supreme Court in Tooth, but still potentially important and in other circumstances. Just to say, you can apply to have the civil procedure rules standard, which is anything which, broadly speaking, anything which supports your case or goes against your case or would support the other party's case, which is much broader. I don't think I've ever been successful in getting that standard, but in certain circumstances where you think HMRC may have documents that you won't have seen that might help your case, then they're going to be relatively rare. It's worth thinking about that.
I'm just going to add two other sort of things that come to mind. Often, by the time you get to preparing evidence for your hearing, it's all, as you say, all come out long ago. And actually the process is really a process of pulling together the evidence that's already been established. You know, the witness statement is repeating stuff that's already been said. So it's not always, or in fact, even often, you're going to be, you know, putting new evidence in that no one's seen before at this stage. The other thing I see perhaps surprisingly often is by the time there are no facts in dispute. But by the time you get to hearing, everyone agrees what happened. They just don't agree as how it should be taxed. And in those situations, you've got to remember that you still need evidence to prove what happens because the burden's on the taxpayer. Unless, of course, you agree an agreed statement of facts with the revenue, which can be a very efficient way of just going, okay, look, we all know what happened here. Let's write it out, get it agreed, and then we don't have to bother with factual evidence at all. So that can be a circumstance you come across.
Yeah, if you've got what is really a purely legal argument, do try to get a statement of agreed facts. It won't always be successful, but it can really reduce the time you're going to need in court. Yeah.
Thank you. Which way do I point it? That way. Great. So, hello. Before I joined Chambers last month, I was actually working at HMRC well, I can see some sort of frowns in the audience. And I was there for about 10 years. So this is my insight into how things worked, how things work at HMRC. So in 22-23, there were around 12,000 new FTT appeals. And in the same year, 7,000 of those appeals were settled before hearing. I mean, they're not necessarily 7,000 of those 12,000, but it gives you a sort of picture, as Rory was saying earlier, that by no means is an appeal to the FTT a commitment to go all the way to a hearing. Rather, it's your only opportunity to get your case reviewed by someone in HMRC's litigation team. And I think that's an important way of looking at the litigation process. An HMRC lawyer may well decide not to defend an appeal, or at least to make certain concessions that an investigator, or a decision maker, as we called them, would not be willing to entertain. I mean, sometimes one might question the objectivity of a case officer who's spent a lot of time investigating a case and may perhaps become personally invested in a case in a way that an HMRC lawyer isn't. So an HMRC lawyer will be completely new to a case, and frankly, we would lose no sleep from withdrawing from a case which has no merit. And in fact, that is, as I'm sure many of you are aware, HMRC's policy. It is the HMRC policy to concede an issue where it believes it is unlikely to succeed in litigation, and that's the litigation settlement strategy. So keep that in mind when I tell you this next statistic. Oh, it's a bit of a lag. Yeah, so in 2021 to 22, HMRC success rate for decided appeals was 88%, and in 22-23 it was 91.8%. And I would suggest that one of the reasons behind that is the litigation settlement strategy. In other words, HMRC had withdrawn from proceedings before the hearing because it did not consider itself likely to succeed. And I think these statistics just go to show that HMRC are pretty good at conceding issues. So by bringing an appeal, you are giving HMRC the opportunity to concede. And that takes me back to the point that a matter will not be looked at by a lawyer unless and until an FTT appeal is brought. The process is not like the CPS, where a lawyer has to sign off a prosecution. Practically, it wouldn't make sense for HMRC to hire enough lawyers to consider every single assessment. Rather, they sometimes rely on quite low-ranking investigation officers to make complex assessments of fact and law. And those assessments will be payable unless they are challenged. It's also important to note that a statutory review won't be considered by a lawyer. So an appeal to the tribunal is really your only opportunity to put your case before HMRC's legal team. And as an HMRC lawyer or ex-HMRC lawyer, in my experience, one is trying to protect the correct amount of tax. I know it might sound difficult to believe, but we're not trying to get more money than is actually legally due. So if we do come across a case where it looks like the investigating officer has got something wrong, we would take appropriate steps. And as an example, before I left HMRC, an appeal came across my desk where it seemed to me that the assessments were too high. So what I did was invite the tribunal to uphold the assessments, but to reduce them quite considerably to the appropriate amount. And the tribunal agreed with that. And if an appeal had never been brought, those assessments would never have been reduced. It wasn't my goal to try my luck to see if I could persuade the tribunal to uphold a higher amount or maybe plead it in the alternative to try and get the most amount of money. I was generally trying to protect the correct amount of tax. In my experience, HMRC are much more likely to withdraw or make a concession if the taxpayer presents well-drafted and comprehensive grounds of appeal.
Chris, I think you're still one slide behind on
Am I still one slide behind? Thanks. No, I'm not. Sorry. That's okay. God, making. So yeah, if you provide well-drafted and comprehensive grounds of appeal, you're much more likely to persuade an HMRC lawyer to concede an issue or perhaps to reduce the quantum of an assessment. When I was at HMRC, I would regularly apply for appeals to be struck out, essentially because the grounds of appeal were not up to scratch. And on that basis, I could argue that the taxpayer had no reasonable prospects of success. And I was actually successful in those applications every time. The tribunal would just strike them out. So keep in mind that while you might not be intending to go all the way to a hearing, this is still a legal process. It's no longer part of the investigation stage, so you can't approach it in the same way. The grounds of appeal need to be properly particularized and well drafted. I'd also note that tone is quite important. An overly aggressive approach is probably less likely to lead to an HMRC concession. And don't try to conceal points or evidence with a view to catching HMRC out later down the line. Aside from the fact that you may end up being precluded from making the point later on, you're missing out on the opportunity to persuade the lawyer with conduct of the matter that HMRC are not likely to succeed. Lesson for me next time is to do fewer slides. So the grounds of appeal are not the only opportunity to persuade HMRC to withdraw. As Rebecca said earlier, witness evidence can be highly effective in showing why your case is more likely than not to succeed. The HMRC lawyer might actually be waiting to see whether you can provide the evidence needed to substantiate your case before withdrawing. And I've also come across many cases where HMRC have withdrawn because evidence has been put in that they've got no prospect of challenging or disputing. And it also gives you the opportunity to see what witness evidence or what evidence at all HMRC are going to provide. You might come to the view that actually they don't have the evidence needed to meet their burden, because sometimes the burden is on them. Which brings me to my next point, which is that you may discover that it is in fact worth going to the tribunal and going to a hearing. By the time a decision has been made and FTT proceedings are in process, HMRC will no longer be investigating the matter. The decision maker will not be interested in digging up information anymore. However, as the taxpayer, you can continue to collect evidence right up until you disclose it. And you can produce witness statements. So that puts the taxpayer at a distinct advantage, especially as you will know HMRC's case already. And taxpayers do have success at the First-Tier Tribunal. In my experience from working at HMRC, relatively few taxpayers are represented by counsel, so that probably affects the statistics somewhat. And given the no-cost regime, a lot of taxpayers bring hopeless or poorly prepared cases, which also probably skews the statistics. Sorry, just one more thing to add, and that's that the cases where taxpayers did the best, in my experience, are cases where the taxpayer had an organized and professional approach to litigation. Very often I would encounter representatives who made procedural errors, which made life very easy for me. Or where the taxpayer is able to provide good witness evidence, often from multiple witnesses, which HMRC was unable to challenge. I think HMRC inspectors don't tend to recognize that a witness statement from someone saying X, or saying that X happened, is evidence that X happened, whereas the tribunal does, recognize that. And the final point is that HMRC sometimes will withdraw because there is some sort of reputational risk. So that's something to think about. Yeah, that's...
Yes, I did. First of all, sorry for interrupting you not once but twice, Chris.
That's okay.
Only with the best of intentions, I promise. So I had a question and a point. And my question was, and you may not know the answer to this, I've always been fascinated to understand, do you know how the statistics on successes are calculated by reference to cases where HMRC is partially successful? It may be that you don't, but I've always been interested in that.
Yeah, I'm not sure, but actually we did have to fill out forms and things when we had a case, which would say whether or not we were successful on certain points. So I think it would probably be whether we, sometimes you get a decision where you lose, but you were successful on like certain points.
But equally, sometimes you have a decision where you win, but were unsuccessful.
I think that's a success.
Right, okay. I'm just interested. That was the first one. And the second one, which was more of a point, it seems that I think one of the things that we've all been saying so far is you vastly improve your chances of successfully resolving a dispute if you get proper advice at an early stage. Mm-hmm. And that was all really, but thank you.
I was going to ask Chris about the last point you make about the reputational risk to HMRC. I certainly have had cases where I think they pulled out because of that, or either because they behaved very badly procedurally and dragged things on, and the judgment's going to reflect that, or they put in poor evidence or things like that, or else it's just the nature of their assessment. But that seems to me contrary to the LSS. To collect the right amount of tax. Is that something that's sort of openly acknowledged to be a reason to withdraw, or is it, subconscious, as it were?
I think it's probably more of a subconscious thing. Yeah, I would say if there's one thing HMRC hate more than not collecting tax, it's bad publicity.
And drubbing in the tribunal. Yeah. Yeah, I think it's just another reason to always make sure you're the good guy in terms of procedure and making sure you do things on time and all of that. If there is delay, you want it to be the revenue delaying proceedings. I think it is helpful.
Yeah, absolutely. It gives a good impression, doesn't it, if you're the person who's got everything right. Mm. Again,
ADR.
Yes, it might be me again.
Ask the clicker.
Could I have the clicker? Thank you.
Sorry.
Oh, perfect. Oh, we've got questions. Brilliant.
I just have a question in relation to the first review process undertaken by an HMRC lawyer. Does that also include a review of the virus of the decision-making of the officer, or is it just as to the tax assessment in a pure legal sense of the merits of the arguments put forward? I'm thinking about whether protective assessment was used in the correct way. Best judgment is what I'm getting at. Does that get reviewed, and if at that first stage, and if not, when?
Yeah, so anything to do with that relates to whether or not you're going to be successful at the tribunal, someone will have a look at that. So, I mean, I'm not saying that every lawyer will consider every single possible angle. They may miss certain things. And I think if you were to raise that in your grounds of appeal, then things that you raise in your grounds of appeal, they are going to look at and take a view on. Yeah, certainly.
You mentioned that the lawyer would look at the papers and make a decision whether to proceed with the case or not. At what stage, or up to what stage, does he make that decision, or can he withdraw at the last minute, or is it early on in the proceedings when he's reviewing the paperwork?
So at any stage during proceedings, if it occurs to the lawyer that he or she thinks they're more likely to lose than to succeed, then they will withdraw. But they will be mindful of the costs implications of doing that. If you get all the way to the hearing and you suddenly decide, actually, no, I think we're going to lose, you're probably less likely to get a concession at that point, just because your HMRC is going to think I'm at risk for costs here for acting unreasonably. But as I think we mentioned, if you were to provide strong witness evidence, that gives the lawyer cause to think, actually, no, we've got no prospect of succeeding here, I don't think they would hesitate to withdraw, because they're less exposed to costs risks at that point, because they can say, well, we withdrew because of this witness evidence. And that's probably a good reason, a good excuse for withdrawing at that point.
Can I take a second point, which was to do with the witness statement and the comment that was made that the tribunal may take an adverse view where, for example, you have a sole director of a company and he is the subject of the inquiry. At what stage, or in terms of the timeline, the introduction of the witness statement, at what is the latest point at which that witness statement can still be brought into the hearing?
Well, the tribunal will give directions that you have to comply with, and they will say the date by which you have to file witness evidence. If you miss those directions, there is always the opportunity to make an application to file late witness evidence, but that's going to depend on, you're not necessarily going to be granted that. Having said that, the FTT is quite informal compared to other jurisdictions. So, I've seen tribunals allow taxpayers to give witness evidence on the day of the hearing, in spite of my objections. But I would always recommend, complying with those directions.
Yeah, I think on that, there is a lot of flexibility. I think the overriding concern of the tribunal is that taxpayers and indeed the revenue shouldn't be trying to ambush each other with new evidence or new arguments. And so if you're approaching it, you've got a sensible excuse and there's a reasonable degree of time before the hearing, as there often will be, then I think most tribunals will be sensible about it and let it in.
But also remember that if you do that, you are putting yourself at risk of potentially unreasonable or wasted costs, most likely unreasonable costs under, is it Rule 10?
Yeah.
Yeah, Rule 10. So just be aware that that's a possibility as well. So ADR, which is Alternative Dispute Resolution, and what I'm talking about here is not what we've all been talking about, which is ways to resolve your dispute, both at and before tribunal, which, of course, trying to get something settled in however an informal manner is an alternative way to resolve a dispute. I'm talking about the official scheme through which you can engage in ADR with HMRC. You can, at various stages, apply to HMRC and ask to have your case submitted to ADR. They don't have to, but you may get ADR. On the slide, it tells you when HMRC say you can use it, when you are unable to reach an agreement during a compliance check, where progress in an inquiry has stalled, at the end of a compliance check when a decision has been made that you can appeal against. And I've just put there, but obviously make the appeal first because you've got limited time in which to make it. So make the appeal, put in your ADR application, but don't sit on your hands is certainly a point to be made. Now, the HMRC then go on to say when you should use it, in their view. There we go. When communications have broken down, disputes about the facts, you think there's a misunderstanding, you want to know why HMRC have not agreed evidence you have given them and why they want to use other evidence. I'm not quite sure what that is, but we'll come back to that. You're not clear what information HMRC has used and you think they may have wrong assumptions. You want HMRC to explain why they need more information. So theoretically, ADR is available in a lot of circumstances, and even theoretically, HMRC say, well, these are good times to use it. I think there are some good circumstances in which to use ADR. I'm partway through an ADR at the minute where we have actually realised that there is a fundamental misunderstanding going on. We've gone away, we're going to put in some more evidence and explain our arguments slightly differently. And I'm very hopeful that we'll actually be able to resolve it to the satisfaction of all parties. So it certainly isn't necessarily a waste of time. one thing that definitely I think puts people off, at least initially, is that you can't just suggest an ADR in the normal sense to HMRC. You have to go through their scheme, and you then have an HMRC mediator who is a person from a different part of HMRC. So you will be being mediated on by an HMRC employee. That can be off-putting sometimes. I've not found in practice it to be any worse than going through mediation with an independent mediator as opposed to an HMRC mediator. However, I am not convinced from my own personal experience, and this is where I'd really like other panel members' perspectives, that HMRC always go into mediations with a problem-solving mindset. I have often got the impression, and I may just have been unlucky, but I've often got the impression that you are there for them to explain to you why you're wrong, and that there may not be a lot of room for manoeuvre. And certainly in the one recently where we've got some movement, I had to take quite a firm approach, which I would have preferred not to have done, but that was where I ended up.
I was just going to chip in and say my experience is exactly the same as yours. So I've done quite a few ADRs, and actually most of the time they turn up, they literally tell you what they've already said, and then they sit down as though, you know, they're dropping a microphone moment. Obviously, that's not the point. The point is to come and have a discussion. Obviously, at least that's in theory the point. The one time where I've had it work was similarly, I think, to Harriet's experience, where there was a fundamental misunderstanding. And once it clicked that there had been a misunderstanding between the two, actually, then we were able to satisfactorily resolve it. But other than that, I would say my experience is the same as Harriet's.
I've had the experience where we've turned up to an ADR, and I understand this isn't uncommon. At the end of it, to try and make it go away, we've made an offer to pay sort of quite a substantial amount of tax, and the revenue representative has turned around and gone, well, I don't have authority to agree anything, and then spent the next 2 hours trying to get the person who did have authority to agree stuff on the phone, and he or she couldn't be found. But I think it's fairly indicative that if you're turning up to mediation and the person you're sending can't actually agree anything, you're not really that serious about reaching resolution. And I understand that that happens quite a lot.
I've had that experience frequently enough that I now at the outset ask if the decision maker is in the room, because that's happened to me on more than one occasion. So literally the first thing I do is say, do you have the authority to settle this? Is there a limit beyond which you can't settle this? Now, I've never actually got to the point where we've got 2 settlements, so whether or not it was actually accurate, I don't know. But yes, that's been a common experience for me as well. However, even if you're not going to get settlement out of an ADR, there can be other benefits, and I just want to mention some of these. You might get a better understanding of HMRC's case. So even if you can't persuade them that they are wrong or partially wrong, or that there's a middle ground, you may better understand where you need to focus your arguments going forward. It might help you to develop your case in a similar way. It might cut down the evidence that you need, because you might be able to narrow issues and therefore narrow points. So you may be able to knock 2 or 3 days off a long hearing. You may be able to avoid the hassle of having to go through certain amounts of witness evidence. It might even lay the ground for things like getting a statement of agreed facts, because you discover that you... So even if you're ultimately not going to get over that hill of actually settling the matter, there can be benefits. And I think if you decide to go to ADR, and I can't think off the top of my head of circumstances in which I would say, yeah, go to ADR where you're pretty sure you're not going to get an actual settlement out of it. But even if it looks like you're not going to get a settlement, don't write it off as a waste of time, and bear in mind these other goals that you can potentially have for an ADR.
Can I just jump in there? Because I've often, a number of times, requested ADR with the express purpose, not of resolving matters, but of narrowing the nature of the dispute, and just saying, we don't really understand your case. Can we sit down and figure out exactly what you say is wrong? And they've been rejected. Because the ADR, it seems to me, from the review's point of view, is a mechanism for resolving the dispute, not for narrowing it. So whether that leaves you in a position where you've got to sort of go in there pretending you want to resolve it, where in fact really you just want to narrow it, I don't know. But
that doesn't seem wholly consistent with the idea, for example, of using it in circumstances like where communications have broken down. Because, frankly, if communications have broken down, you may well have no idea whether or not you're potentially going to get a resolution, but you might be able to reopen communication, which in and of itself might be an important achievement. towards resolution, but isn't a resolution. So yeah, that's disappointing. That is disappointing.
Yeah, I was just going to make the point that as far as I understand, during ADR, the HMRC lawyers are not involved in that at all. So in the same way that you're not going to get a lawyer to look at your case unless you make an appeal to the FTT, they're not going to look at your case during ADR. That's just going to be a meeting between the decision maker and the lawyers on this side. Although I will note that the ADR facilitator, they are very independent in my experience, because I've had decision makers say, oh, okay, I don't really want to have to do this. And the ADR person will say, no, we're going to try and sit down and try and figure something out. So while you won't be able to have a discussion with the HMRC lawyer, so you're not really going to understand their case yet, you will, it is an opportunity to, speak to someone who is trying genuinely to settle things.
Chris, and I agree with that. I think that's why I said some people are put off by the fact that it's an internal HMRC person who is the mediator, but I've always found them to be pretty even-handed. So, yeah, I completely agree with that. That. I was not trying to say they weren't, but some people do find it at the outset a bit off-putting. So, just before I leave ADR, I want to bring up the litigation and settlement strategy again. Now, this is the policy which governs how HMRC are supposed to resolve disputes. And I think it's crucial, both for litigation, but particularly when you're trying to settle something, that both you and the client understand the limitations this potentially imposes on settlement. I've found that it's vanishingly rare now that the LSS has departed from in a general sense. I know when it first came out many years ago, people said, oh, well, you still get inspectors who are willing to sort of horse trade. I've not found that to be the case in practice. I bow to other people's experience though, of course. And what I would say is the LSS doesn't stop a settlement, but one of the key points that you need to be aware of when you're looking at getting a matter settled is that HMRC won't settle where they won't make a settlement not in accordance with the law. They won't horse trade. They won't take two matters together and say, well, we'll drop the corporation tax if you give us the PAYE income tax or something like that. Because it has to be in accordance with the law, and it has to be in accordance with what they think the law is. Now, again, this doesn't mean that you're never going to get anywhere. You can use it to help you in ADR. So the first very important thing is anything that you want to say, any proposal that you want to put, you need to think about how you can fit that within the LSS principles. And that's really important because sometimes you will be able to draw a distinction. I can remember getting a settlement once. It was in the context of transfer of assets abroad. And what we did there was we drew a distinction on a factual basis between different years. So we got the motive defence for a certain part of the time, but we said, yeah, actually we accept that something which happened in year Y meant that after that the motive defence had gone. And so by couching that in a way that showed that it was in accordance with the legislation, we were able to get a settlement that was acceptable to everyone. The other thing that is important to do is just make sure that HMRC are doing what the LSS says they will do. So it talks a lot about cooperation, collaboration, being open to settlement and all the rest of it. And particularly, I found it particularly useful in an ADR setting to just make a note of when those things are blatantly not happening and then bring those all up together at one point to get a bit more of a cooperative approach can be really helpful. So the LSS is it's not a restriction, it's a framework, and you can use it to your advantage. And I do find that particularly useful in ADR. But ADR, yes, can absolutely be worth it, but it is an extra cost stage, so just bear that in mind, and deciding whether or not to even apply for it or accept an offer of it can involve costs considerations. If you are offered it, I would probably almost always give it a go, because that tends to mean that HMRC are, if you're offered it as opposed to asking for it, that tends to, I think, and Chris might correct me, be an indication that HMRC are thinking about settlement.
Yeah, no, I would agree. One point I would make, though, is be careful what is put in the exit agreement, because sometimes I think people don't pay too much attention to it, but that document does sometimes end up before the tribunal in a hearing. And I recently had a case where I used that document when I was working at HMRC as evidence of something that was said by the appellant, which they were disputing, and I could say, well, look at the exit agreement. So be careful what you put in that, because that may end up, not being so helpful later down the line.
Can I just ask you to go back to the slide where you mentioned the compliance check? Can you just explain how that fits in?
Sorry, that would be this is HMRC, where HMRC said this is. Yes, so this is HMRC, and this is what they say on the website. When you're unable to reach an agreement.
Can you explain what a compliance check is in the context of an inquiry, questionnaires?
So, well, it's going to be something like an inquiry or an informal request for information, where HMRC are trying to get at the right amount of tax, and you fundamentally dispute a point within that. It could be, I don't think you're entitled to that information. Theoretically, you could ask for ADR on that point, so that you could try to understand why HMRC say they need it. And actually, that's possibly quite a good example, because if providing the information might have a really significant cost, say it might be costly to recover the information just because of the amount of what's being asked for, that might actually be a really good place in which to say, look, we don't think you need this. We don't think this is going to help you. Let's sit down and talk about it in a mediated manner. So that's a possibility. It might be about whether or not they're entitled to make a check. So you might even be right at the start of that, and you might be saying, well, I don't understand the basis on which you're doing this. I don't understand the legal power that you say you're using to do this. That might be an opportunity for ADR. It's going to be very fact-specific, and I have to say that is never something that I have done or that I've considered doing, using it in the course of a compliance check. And if anybody has, I think it'd be really interesting to hear their perspectives on that.
No, I took compliance check just to be a sort of general non-technical term to cover
Yes.
all sorts of inquiries
Yes.
and stuff.
Yes.
And you can see in the course of that, for example, the type of thing which might get referred to the tribunal could be the sort of thing which is worth having a discussion in ADR about before you
Yeah.
move on to
Yeah.
the next stage.
Yeah, I mean, I don't know, but it certainly occurred to me that a compliance check is a sort of precursor to possibly. We want to find out a bit more, because we may want to raise an inquiry. That will come at a later stage.
I suspect the inquiry would be already raised, given the time limits.
Okay.
I'm sorry. Yes.
Is there a practical deadline as to when an ADR can be asked for before a hearing in the panel's experience?
So there isn't an unofficial deadline, but obviously there's going to be in terms of using the HMRC ADR process, you're not going to be able to get that organised that quickly. So deciding, a month before a hearing that you'd like to is probably not the best idea. And of course, the closer you get to a hearing, the less the cost benefit is going to be. So there's no point in trying to go for it too early, because it's probably not going to achieve anything. But probably these points that we've talked about along the road, so we've talked about, when I think Rory talked about when you might get to re-examine your case, it's probably a really good idea at each of those points to think, actually, is there anything here which makes it more likely that I can get HMRC to settle? Is it more likely that we can come to an agreement on somewhere? And so, when you get their statement of case, when you do witness evidence, possibly even when you see a list of documents, I can't remember all the ones you said, but those are probably good sort of like waypoints to think about ADR.
But yeah, though I think, even, if a week before trial, if both sides say to the tribunal, hang on, we've decided, having reviewed each other's skeletons, we want to go to ADR, the tribunal may well be happy to stay and postpone the hearing to allow that to happen. So probably no time is too late.
No, and indeed, no time is too late to consider settlement in a more informal way either. I mean, rarely, but occasionally you see it that you manage to settle something partway through a hearing. So, for example, if you had a witness catastrophically collapse, your view of the case might suddenly change, and you might decide that probably wasn't worth the candle to go the rest of the way.
I mean, we thought sort of exchange of witness statements was a good time to really appraise the strength of the arguments, and frankly, hopefully that will have leverage in the negotiations at ADR.
I think that must be right. And I think Chris's point about sometimes inspectors don't appreciate that witness statements are evidence, and particularly where you've been banging on about this has been happening and you're getting a response of, well, there's no evidence of that, that can be a good time to try and encourage a re-evaluation. So I think there's another question up here, yeah.
Just wondered on the panel's experience of the revenue applying for ADR themselves to avoid putting statements of case in on time. What experience have you had of that?
I have seen that where we've had a suggestion of ADR, and where it's a sort of case where we've gone to tribunals specifically to get a statement of case. The response has sort of been, well, fine, but we want to see your statement of case first, because there's not much point in sitting down and having a discussion when we don't know what your case is. So I think that does happen, and I think it's sort of done as a last throw of the dice to avoid sort of that step taking place. And one of the questions which you have to decide is, well, is it better going for ADR now, or without being unhelpful and uncooperative and saying we're not going to engage in ADR, but saying, well, we're happy to, but once we understand your case and once we've seen a statement of case. And I think that's a perfectly reasonable approach to take.
At the ADR, HMRC makes the statement that everything that is mentioned is on record and nothing is without prejudice. So it can be used before the tribunal hearing. Has the panel come across a situation where the HMRC, in admitting the documents for a tribunal hearing, have refused the inclusion of the HMRC's opening statement?
I haven't, but I don't think I've come across a case where where we wanted it in and they didn't. So difficult to say. I don't know what.
I haven't.
Has that been your experience?
Yes, that has been the experience, where they have refused to allow the statement which the revenue made at the ADR hearing, opening statement, to be included within the documents.
Sorry.
Yeah, well, I would have thought that there would have been an element of privilege applying to the discussions in any event, even if not legal privilege without prejudice privilege, because the whole idea is to have a discussion and for the parties to have that discussion openly. That isn't helped if you know that whatever you say in the course of an ADR is subsequently going to end up in tribunal later. So I would have thought there's some merit to the revenue's position that they don't want it in there from a legal perspective. The exit agreement may be different because that sets out what the parties have actually agreed. And Chris mentioned that even there, you may have an argument around it. But in terms of the opening statement, I don't think the revenue's position there is necessarily an unreasonable one.
So I think we're headed costwards now.
Okay, so this is not the most exciting topic. Unfortunately for you, I did a costs application yesterday, so I'm excessively prepared for this. The starting point then, thinking about the cost risks in the FTT and beyond. So although there aren't usually cost consequences in the FTT, which I'll come on to, it's important to remember at the outset that A, this is not true in certain circumstances, and B, a cost regime does generally apply as you go up. Which you may not be in control of. If you win in the FTT, HMRC gets permission to appeal and goes to the upper tier, and then they win. You can, in this instance, try to get HMRC to agree to something called a Reese practice, which is where you try and get them to agree that costs will continue as in the FTT, so everyone will bear their own costs. And this is particularly when there's a risk of financial hardship to the person who's won in the FTT, and it's an important principle. It is contained in HMRC's manual. I have never actually seen HMRC agree to this, in reality, and I did do some research. So I don't know if anyone has had more success than me on that. But the other thing as well to consider is a protective costs order, which I'll come on to. So what's the normal position when the appeal has not been allocated as complex? Well, each party will pay their own costs. However, there are some very important exceptions which are set out in Rule 10, and this is wasted costs, as Harriet mentioned before, and this is under 29(4) of the 2007 Act, or, and more commonly, if the tribunal considers that a party or their representative has acted unreasonably in bringing, defending, or conducting the proceedings. So just to briefly touch on the first of those, a wasted costs order. This is where costs have been incurred because of improper, unreasonable, or negligent acts or omissions on the part of any legal or other representative, or any employee or such representative. It's considered by the tribunal that it's unreasonable to make the losing party pay, the winning party pay, sorry. More commonly, however, costs are applied for when a party has acted unreasonably in bringing, defending, or conducting proceedings. And an order can be made either on the tribunal's initiative or by a party making an application. Orders can't be made without giving the other party, so the person who'd end up paying, the opportunity to make representations. Now, in terms of bringing the proceedings, this is going to be particularly relevant to taxpayers. It's important to note that just because an argument is weak, it doesn't necessarily mean that it's unreasonable to bring proceedings. But if you've got a case which is clearly untenable from the outset, there is a real risk that the other side is going to make a costs application. Similarly, cost applications are made where there has been unreasonable behaviour, for example, consistently failing to follow directions or making unnecessary applications which need to be responded to. The key cases when looking at this area is a case called Distinctive Care in the upper tier and Patel as well. These cases highlight that a single act or omission can be unreasonable conduct, that the handling of the case overall needs to be looked at, so the standard that both parties are operating with is relevant, and also that whilst you can look at things that have happened earlier, and certainly that is relevant, your focus should be on the actions that are the subject of the costs application. So if, for example, you're doing a cost application because you feel the other side has made an unnecessary application and you've had to deal with that, ideally the focus would be on that rather than earlier behaviour, but it can be looked at. Now, in terms of how to make a costs application, you've got to complete a schedule of costs, and this has to be given in sufficient detail. So Distinctive Care in particular sets out that for fee earners, so solicitors and accountants, it's important to set things out like hourly rate, geographical location, and the level of expertise. So that's cases where you're not on the complex track and you are instead default, basic, or standard. Cases where you're allocated as complex, so this, in these situations, taxpayers given 28 days to opt out. The consequence of being allocated as complex is that the cost regime will apply. So instead of the usual rule that each party pays their own costs in the FTT, normally the costs will follow the event. So normally the winner will get their costs. Where a taxpayer's costs are quite high and their arguments have merit, it can make sense to remain in the cost regime, as HMRC's costs are likely to be less. Although Harriet and I recently had, and this was in the upper tier, but we recently had an experience where we had a one-day appeal and HMRC's costs were about 25k, and you thought, how on earth have you got there on your rates? Yes, so in theory, they should be significantly less. So it is something to factor in.
It was only on one issue as well. There was like literally one legal issue.
It was madness. Costs, though, can be challenged for being unreasonable or disproportionate if the assessment is on the standard rather than the indemnity basis, as it normally is. And things to look out for would be where work is being done by someone far too senior. So if your KC is making a bundle on an hourly rate, you might... That's the KC who led me yesterday. you might query whether that's a legitimate thing to be doing. More commonly, you might, for example, see a partner's carrying out the email correspondence with the tribunal and charging the hourly rate. You might want to query that. And in mine and Harriet's case, one of the points picked up on was that there were two counsel on this reason. It was one issue, and it wasn't that complicated.
It was one issue. It wasn't a complicated issue. It was, I think we were pretty much diametrically opposed, but the facts, no one had any issues on that.
I mean, I'm hesitating to criticise too much because, of course, I was with Harriet, so we had two counsel.
Yes, but we were acting pro bono, so
We were.
not that we do that regularly.
No, not at all.
So yeah, and also the tax involved, which is why we were acting pro bono, was tiny.
Teeny weeny.
Yeah, it was a very small amount of tax, but we considered it to be an important issue. Apparently HMRC did as well, but wanted their costs for it.
Which, not very charitable. Anyway, so what happens as we go up? Well, once you go up to the upper tier and beyond, as I've mentioned, cost regime generally applies. You might want to consider applying for a protective costs order by seeking a direction that no order for costs should be made. But of course, this would also mean that if you're successful, then you're not going to recover your costs. So it's something to factor in. And weighing this up is going to depend on both the merits of the case and, again, how high the taxpayer's costs are. So, yes, that's what I've got on costs.
I was just going to say, I'm always surprised by how hard it is to get a protective costs order when you've won at the first tier and you're appealed up by the revenue and you're exposed to potentially quite significant costs of the revenue. In what's supposed to be a no-cost regime, and you would have thought taxpayers would fairly easily be able to get a protective cost order if they're not wealthy in those circumstances. It's actually very hard. You have to essentially show you have no financial interest in the outcome.
Yeah, or I think, yes. So, I mean, there are two things. That needs to be sort of like a point of general interest, doesn't it? Yes, yeah. And you need to be able to show that you are unlikely to take the case without a PCO. And that you have no financial interest, or effectively that your financial interest is sufficiently small that it doesn't weigh heavily in the balance. So it is difficult to achieve. The case, I think, is still corner house, isn't it, in the Court of Appeal? But yeah, it's they're rare beasts.
So just one question on costs. Is bearing its mind the implications for our clients on the categorisation at the outset of the appeal, is there realistically any way of it attempting to persuade the tribunal at that outset in its categorisation decision? Because it can make quite a significant difference to the costs for our clients.
Well, I think if you want to be within the complex category, then I think that there has been case law on what a complex case is. But your opportunity to do that, it seems to me, would probably be in the course of your grounds of appeal. And if you're setting it out and making it very clear that this is a complex case which raises lots of issues, then I think you're more likely to succeed on that. You can ultimately challenge a categorisation as a standard case if it's felt appropriate and necessary. But again, the downside of that is you're adding costs at a point when you don't know if you're going to be able to recover them. But it's something worth considering.
Yeah, I mean, I guess it would be most common for our clients that they want it to be heard on the papers rather than actually have a hearing, just to keep costs down.
Yeah, and in that case, I think you're probably unlikely to get a complex case.
I think in terms of going between the paper and the standard track, realistically, it's going to be just as costly to challenge that categorisation as it is to just proceed to the standard track case. I suppose you could theoretically, if you manage to push the case far enough along, say if you manage to agree facts, for example, you might be able to ask for the tribunal to reconsider its categorisation, or ask HMRC to agree that it should be a paper case. But again, the cost of that's probably going to outweigh the benefit.
Yeah, that was sort of our conclusion as well. Once the decision's made, you're sort of stuck with it, aren't you?
At that level, yes, and where the objection is to costs is because the standard is too expensive. I think, yeah, you're better off just sucking that up, to be honest.
Yes, judicial review. We decided it would be remiss of us to look at tax litigation without touching on judicial review, but of course it's a whole subject in itself. So probably the best we can do in this format is to just touch on some of the interesting facets of how judicial review and tax overlap. But of course, the starting point I think is to understand how judicial review fits in to tax disputes. And the basic point is that most decisions of HMRC, most assessments of tax are appealable under the tax legislation and the relevant law on what you can appeal and how. And in those cases, although it's an exercise of a public authority, judicial review isn't a revenue available to you because Parliament has provided you with an alternative one. But this does leave a number of decisions of HMRC that cannot be challenged through the tax tribunals. Many of them will be informal exercises of discretion, but there's also some formal decisions. I've listed there APNs and follower notices are two types of revenue decision where they can give you a notice that has consequences, but you can't appeal those to the tax tribunal. You can make representations, but after that, your only avenue for challenging them is judicial review. There's also often what we see in tax is legitimate expectation judicial reviews, which the principle being there that you've been led to believe that HMRC will behave to you in one way or another, and they've changed your mind, and you see that you claim that's unfair and sufficiently unfair that their decision should be reversed. So these are these types of challenges against the revenue that don't fit within the tax legislation. And your option really is to go to the High Court and ask for them to be overturned. You can also, I know there, challenge legislation itself on the grounds that if it's secondary legislation, that it's ultra-virus, that it's beyond the bounds of the primary legislation, or alternatively, you can challenge the interpretation of that legislation by HMRC if you think that they're misinterpreting the law, and therefore their actions are not in conformity with what the legislation says. Essentially, abuse of powers. If they're exercising powers you say they don't have, judicial review can present an answer. The first one I think perhaps is we have an entirely different, as I said, it's an entirely different area of law in almost every way, entirely different type of litigation in almost every way, entirely different principles that you need to argue, and entirely different procedure that you need to follow. The key sort of principles that underline judicial review is the concept of reasonableness and proportionality by the public authority, in this case HMRC. And the point to note about that is it's a very high bar in judicial review. Where statute has given HMRC a job and a discretion in how they do that, you're going to have you can't just disagree with their decision. You have to be able to show that it's an entirely unreasonable and disproportionate means of exercising that discretion. You can also challenge due process with judicial review. You can say, for example, they haven't considered my arguments. I haven't been given the chance to so for example, with accelerated payment notices, the Court of Appeal has made clear that before the HMRC issue with an accelerated payment notice, they need to give you a chance to make your substantive case, even though that's not required by the legislation. So there's various attacks you can make on the revenue about saying, well, you haven't followed the process that you're supposed to have done in terms of considering my rights. I think the risk there is that what often happens in this situation is, well, the court might find, yes, they didn't properly give you, they didn't go through the right process, but the outcome would have been the same anyway. And so your claim fails, or at best, they say you didn't get fair process. We'll quash the decision, and HMRC will get to make it again, and you know what the outcome will be. And I mentioned also their lawfulness, as I say, the situation where HMRC are acting outside their discretion. So those, and in each of those concepts, I very briefly touched on, have their own very substantive case law that's going to be worth considering in every situation. So as soon as you have this kind of dispute with HMRC, you've got to be thinking with a very different mindset. It's also, as I mentioned, an entirely different litigation procedure. We're not going to the tax tribunal for judicial review generally. We have to go to the High Court. We have to go to the High Court under the CPR, and we have to follow the rules there. So there's cost exposure straight away. And it's also worth noting that judicial review applications are front-loaded. You have to make essentially your full case right at the beginning, and then you apply for permission to bring your judicial review. The revenue will almost certainly challenge that. You might get refused permission, or you might get permission, and then you go on to a full hearing. That means you're going to front-load a lot of your costs, and you front-load a lot of the cost risk. The other point to make is that there's two reasons you can often not be allowed to bring your judicial review, which need to be considered again right at the beginning. Which is, the first is there an alternative remedy? The High Court will generally disallow permission to bring judicial review if it thinks you have another way of satisfying yourself against the person you're complaining about. In our case, it will mostly be you should have gone to the tribunal to resolve this, you should wait until they assess you to tax, and then you can go to the tribunal and that sort of thing. So those arguments are fought quite hard by HMRC, so you've got to be very clear about them right off the bat. The second is that you've only got 3 months from the decision that you're disagreeing with to bring your judicial review. So again, unlike tax disputes, which tend to drag on forever and trundle along very slowly, judicial review moves quite fast. And you've got to get in there quickly, and if you don't, you won't be given a lot of, you won't be treated very generously if you wait years. And that can present practical difficulties because the nature of the way the revenue works, for example, but also the nature of the effects of some decisions, is not always immediate, as it might be in different judicial review situations like immigration and things. So there's a lot to think about if you find yourself being treated unfairly by the revenue, and when you're asking yourself, well, can we challenge this? Not as a question of how much tax is due in the tribunals, but challenge a different type of decision. And you have to be fairly decisive quite early. There's 2 other complications I've mentioned there at the end. The first is the problem of split proceedings, because often the case in a tax litigation situation where you're disputing a tax assessment, which must proceed to the tribunal, but you're also complaining, say, of legitimate expectation. You're saying, well, they shouldn't be assessing me because I have a legitimate expectation. They told me they wouldn't, so I did something, and they've assessed me anyway. Well, that's the kind of thing you can challenge through judicial review under the concept of legitimate expectation. But you also want to challenge the assessment. You're also saying the assessment's wrong. And you can't do both of those things in the same place. So you have to launch tribunal proceedings and judicial review proceedings in the High Court at the same time. The second facet of that oddity is that the upper tribunal can entertain judicial review. So what you see sometimes is the judicial review will be launched, stayed, whilst the FTT decides the underlying tax liability, and then you appeal that up to the upper tribunal where they'll be joined again, which is both time-consuming and expensive in terms of getting your judicial review through. It's also, in many ways, logically backwards, because whether the assessment is valid doesn't matter if they couldn't have made it in the first place. So that can be a bit of a sort of, Kafkaesque nightmare, really, in some cases. And something to bear in mind, again, right at the beginning, because you want to make sure if you are trying to do that, you get both proceedings started at the same time. The other developing area, I think, of law is the Henrik Zeeman and Beadle cases, where there's a grey area, in fact, developing to the extent to which the First-Tier Tribunal can consider public law issues and HMRC's exercise of them. So we've been all operating for a while on the basis that it can't, and everyone knows it can't. The upper tribunal have told us recently, well, it can in certain circumstances. And unfortunately, when it can and when it can't is in itself a very difficult question that depends on the interpretation of the legislation. So it very broadly, what the upper tribunal have said is that if if the legislation describing HMRC's powers implicitly rules out judicial review and makes the tax tribunal the only way of challenging that decision, then you can argue public law and judicial review arguments in the tribunal, which sort of, I guess, may make legal sense, but it also makes it incredibly practically difficult to know at the outset. You've got to interpret that legislation in quite a subtle way.
And I have to say the decisions so far don't give me much help in interpreting legislation in terms of am I in or out.
Yeah.
Yeah.
Which might inevitably lead on a practical basis to, well, you've got to try both and see, one or the other will get struck out for jurisdiction and the other will be allowed to proceed. But obviously, again, cost, risk, etc. there. I've mentioned costs already. There's very little protection in judicial review and it's front-loaded, so that's also a large... I mean, often, you're asked to consider, do we have a grounds for judicial review? And the answer is, well, they're not strong and the cost risk is so high that it rarely turns out to be worth it. But it's worth considering sometimes.
Yeah, just a point on the time thing to be aware. It's 3 months, but it's also promptly. And so it's not a case that you can wait to the last day of the 3 months and issue the proceedings, because the revenue will take the point that you haven't done it promptly, as in you should have done it earlier, and why have you waited to the last day of the 3 months? Now, that seems a nonsense in a case where it's been waiting 2 years to have a decision and where it's just about payment of an amount of tax, which there might be tribunal proceedings sitting behind, but they do take the point, and the administrative court judges do take it seriously. So while you have, in theory, 3 months, you need to be making use of those 3 months and getting a move on.
And a good way to show you're doing that is to make sure you're complying with the pre-action protocol, but you need to get that underway quickly because there are time frames within that which are in and of themselves reasonably lengthy in the context of a 3-month absolute deadline. So yes, but there is a pre-action protocol and you want to be cracking on with that pretty soon after the decision is made, if at all possible, though we all know that clients usually come about 6 months after they've had whatever it is they're complaining of, but there we go.
Anything else? Any questions?
Well, that brings it on to me, and sorry, the last section, which we've entitled strategy. I have to say most of the points which I was going to make here have been made in the course of what we're talking about. I suppose the first one which is there, which I would make, is litigating in the tribunal. It's not like an episode of Suits or one of those fancy legal dramas where everything's very exciting and you can pull these fancy tricks in order to win your case. Unfortunately, the best strategy, it seems to me, is a boring one. It's avoid the sort of clever applications. They don't tend to work. They tend to piss off the tribunal, and all they do is add to excessive costs, unless you've got something which there's very clearly a purpose for, and it is actually going to save costs. So, for example, where there's a single point to decide the whole thing on, it can make sense to seek to have something dealt with as a preliminary issue or even strike it out. But for the most part, it makes sense to play it straight and work on the basis of the case. Consider the position soberly and carefully at an early point, work out what your case is, what it is you're trying to achieve, and how it is you're going to go about achieving that. Now, that seems incredibly obvious, but it's amazing how often, simply by not taking a step back and considering the position, we clients can find ourselves sort of heading headlong down a road where we don't necessarily want to be. And the best way of ending up where you want to be is knowing where that is and knowing how to get there. And that requires thorough preparation. It requires proper thought into what evidence there is, how it can be deployed, how does it relate to the issues, because you may well know what the issues are, and there may have been lots of discussion over sometimes quite a long period of time as to the correct interpretation of legislation. But very often, and it will be the case because the issues are obvious, less thought has been given to, well, how do we show that this actually did happen? And how do we show that it happened, bearing in mind that something might have taken place a long time ago? Now, we've talked about witness statements, we've talked about documentary evidence, corroborating evidence, all these factors. At an early stage, it makes sense to consider that, consider how to put it together, consider how compelling is it? Is a tribunal going to believe this? And it is very important to think, well, I'm saying that this is the case. Is that believable? Or my client is saying this is the case. Is that believable? If not, what can we do to bolster that, to make it more believable? What can we do to show that actually this really was the case? Do we need more witnesses? Do we need more documentary evidence? Do we need something else to back it up? And also bearing in mind that witnesses, they are often going to be giving evidence a long period after the events have happened. And this brings in the point which I mentioned earlier about having documents to back up what they're saying tends to refute the argument that, well, actually, this is a witness. Witnesses have fallible memories. Don't believe what they're saying or don't give them an awful lot of weight. If the witness is saying something, if a document shows that what he's saying is consistent, then that makes it a lot more compelling, gives it a lot more weight. But giving thought to this at an early point in time when this is all being put together is absolutely critical, rather than getting to tribunal and the point being made, well, there's no document underpinning that, and then sort of running off and going, oh, well, we had a document, why didn't we use that? It's a bit late in the day and it's a bit unhelpful. Also, when we do have witnesses, remember the evidence will be tested. There is a sort of huge temptation to say X, Y, or Z in the belief that this is going to really help my case on the part of the witnesses. But it might be an exaggeration. It might even be an untruth. I remember once having a witness who insisted that the story was correct and it was absolutely right. I pointed out that it was a bit inconsistent with the documents. He insisted it was right, and I did tell him it would be tested. We got to tribunal. He'd basically forgotten his story and started on a whole new one. And you can imagine how that went. Not very well. So there we go. These things happen. But it is good to sort of try and address it at the outside and beforehand. As I say, we can have lots and lots of evidence, but if it's not relevant to the arguments, then it's not probably really needed, and you're probably just wasting time and cost pulling it together. Also, and I think this goes to sort of discussion points which have been made before, how does the evidence relate to discussions with HMRC? As Chris said, HMRC may be waiting to see what evidence we have. It might be a good point to suggest ADR after we've provided the evidence. Does that help in reaching a settlement? And also, along the way at each of these steps, considering a settlement, sort of when, how, what amount, do we think this is something which can be achieved consistently with the litigation settlement strategy? Because while you may have to pay some tax on a settlement, you do have the enormous benefit of not being dragged through the tribunal proceedings over periods of time. It can be stressful for clients. It can be something they don't want to do. And it draws an end to the costs. And so I think keeping an open mind to the possibility of settlement at all points, whether through ADR or elsewhere, it is also important to do. But your chances of achieving that, it seems to me, become a lot better if you've been preparing your case properly and if you've got rock solid foundations for it, so that when you go to the tribunal, you're going to be in good stead, and so that you hope that the revenue advisors can see that when you go to the tribunal, you're going to be in good stead, and maybe this might be a time to reach a sensible compromise. So that's all I have to say on strategy, but I'm sure that the others around me will have different views. Seems that I'm universally believed. That makes it first.
You are the silk, Rory.
Well, in that case, and given that we're coming to the end, it's probably worth asking if we've got any questions, and maybe if we can take the questions from the Zoom as well. But sorry, sir.
Thank you. I was the progenitor of the Amrolio case, which got as far as the Court of Appeal. And we applied for leave to appeal to the Supreme Court. That was refused, so we then applied to the Supreme Court's Appeals Committee, and that was refused, but no reason was given. So I wrote to Lord Reid and said, what were the reasons? And I got a snotty response from a secretary to say that judges don't have to give reasons, which I thought makes a bit of a mockery of the law reports. But this leads on to my question. Part of the judgment in the Court of Appeal in Amrolia was that when there's an inquiry into a partnership tax return, there's a deemed inquiry into each partner's tax returns. And Lord Henderson made it pretty clear that that was a full inquiry. And Section 9A says an inquiry extends to anything contained in a return. But I'm getting a difference of opinion from HMRC, from a senior inspector at counter avoidance, saying that their interpretation is that the deemed inquiry only relates to that partner's involvement in that particular partnership. So my question is, will I be wasting my time if I write to Lord Henderson to ask him for his response?
Practically, yes.
I expect it would be, yeah.
Sorry, Rory.
Yeah, unfortunately, you do sometimes get decisions which don't seem to fit together with other parts of the legislation and other people's views, but it is a decision of the Court of Appeal and it will be binding.
Well, if I want to challenge it, have I got to go for judicial review?
Well, I'm not sure you can challenge it. Unless you could get your case into the Supreme Court, it's going to be binding. Because
well, Lord Henderson's judgment is binding, but he said it's a full inquiry.
Yes.
And yet I'm getting this senior officer saying
do you want a full inquiry?
Yes, I do.
Well, in that case, I think you've got a very good basis for saying you have one, because you've got Lord Justice Henderson having decided the point in your favour.
But the man at HMRC doesn't agree with me.
Well, I think that's where we get to. Sometimes the revenue's approach doesn't necessarily reflect the law, and that's where moving towards having their lawyers interpret and apply these things can be important. And so it's a matter of how do you get that in front of the right person to consider the point.
Okay.
So if we look at some of the Zoom questions, I think I've got one here. There's no right of appeal against interest charges, but with inquiries and particularly old tax schemes, the amounts become draconian. HMRC's interest unit back any claims back that any HMRC delay after notifying inquiry is not unreasonable, even if after many years of zero activity by HMRC or even a zero APN charge. JR may be the only option, but does the panel have any experience or views on mitigating interest, please? I don't. The only point I would say is that it might not only be judicial review that you could challenge that sort of thing in. In order to collect interest, the revenue will need to bring proceedings in the county court, and you can raise public law defences. And if they're trying to collect a sum which is unreasonable, and you would have a good public law ground for not paying it, that may be an alternative avenue to doing that, and it may be a sort of cheaper and more pragmatic one, but not one for the faint-hearted, I wouldn't have thought.
Roll and see if we've got some more questions.
I think there were some more.
Yeah. Right, just bear with us. We're just scrolling for questions at the moment. Yes, while we're sorting it out.
Thank you. The question was about the reviews process, and it was discussed that before the review, internal review, you wouldn't have a HMRC solicitor, a lawyer, look at the case because it would come later. Normally the review is conducted by somebody from the solicitor's office. To what extent can you get a solicitor involved at that stage?
It's true that the review team sits within solicitor's office, but they're not connected to solicitors at all. So there's no way of insisting that the review officer involves the legal team. It's just, they just happen to sit in the same department. If you'll have to bring an appeal to the FTT.
Thank you.
Have we got any more questions in the room just while we get to the Zoom ones? Yes. So I would say that where you are seeking to use technology, don't let me anywhere near it. Sorry, I can hear myself in the room for those on Zoom. Brilliant, thank you. So I would say, in terms of your first question, it's going to involve an assessment of how, I mean, I would say, yes, probably do give the information, particularly if it's sort of like factual information about the nature of the R&D, because I don't really see how, I think ordinarily, yes, you're going to want to give that sooner rather than later because you're unlikely to get the outcome that you want without giving it. So you may as well give as much as you can. However, you would be well advised to take advice on what type of evidence you want to supply, how you want to produce it, and how you want to present it, I think, on the first one. Does anyone else want to take the second one, or indeed the first one?
I was just going to say on the first one, it seems to me, there's nothing prohibiting you from using evidence you produce during the inquiry stage, even expert evidence, and submitting that as expert evidence at the tribunal stage. You'll need to get permission from the tribunal to rely on expert evidence. And there's nothing saying, well, it's expert evidence we got earlier. Can we rely on it, please? The trick is making sure it's sufficiently objective when you get it, and that you're not open to a charge of HMRC in the inquiry saying, in the tribunal stage, saying, look, this is a member of their team. This isn't an objective expert evidence. This is something that they got earlier. So complying with the CPR rules on expert evidence are quite advisable. Yeah, well, because otherwise you're at risk of not being allowed to use it and then having to go and get expert evidence again in a compliant way. I think that's probably the risk.
Right, we're approaching the end, but if we perhaps deal with a few of the Zoom questions. So the first one is about a case where there's tax inquiry, HMRC agreed with what was suggested and offered a revised calculation settlement with a substantial refund of tax. That was agreed and a closure notice was asked for, but HMRC have now come back with more questions and the offer has effectively been withdrawn. And the question is just wondering what grounds they have to do this, as it seems unfair. We're considering threatening HMRC by appealing to tribunal. Do you have any thoughts? That, I have to say, is something which I have come across before, where taxpayers' advisors have managed to reach an agreement with a revenue inspector, and it has gone elsewhere within the revenue for confirmation that it was accepted, and it has been withdrawn. And it does seem entirely unfair that, having apparently reached a compromise, the revenue then go back on it. Unfortunately, in terms of what can be done about it, it seems to me not a huge amount. Possibly judicial review, but it's always quite difficult to find grounds in which to challenge something like that. That said, others may have different views.
I was just going to say that I've had exactly the same thing happen. So we've managed to get something that looks like it's finally across the line. They go off for final confirmation from someone else, and then they withdraw it. And yeah, I mean, there's not really much you can do. It's very frustrating, but yeah.
Next question. If HMRC begin an inquiry which is answered in full and then nothing is further is heard from HMRC, is there a point at which the inquiry is deemed concluded resolved? How long before the matter can be considered closed? I think the answer on this is probably it's not closed until you get a closure notice, and what you need to do is go off and ask for a closure notice. Harriet and I did a case a number of years ago where something similar happened, where the taxpayer had an inquiry opened into him. He provided the details, didn't hear anything from the revenue for 7 years. At that point, they then changed their policy. It was in relation to employee-related shares. They changed their policy so that whereas previously he had an allowable loss, he no longer did, and there wasn't a lot he could do about it. And part of their answer was, well, if you'd applied for a closure notice, then you would have been fine, but you didn't, so tough. So I think it's very dangerous to just sit on things, and if you think the inquiry's closed, then the proper course is to write to the revenue and ask for a closure notice. And if they don't, you always have the option of applying for one. Maybe if we just take a couple more questions. If one goes to ADR, is it possible to enforce that the original decision maker, i.e. caseworker, is present? That's one for you, Harriet, I think.
I can see absolutely no way that you could enforce that. I mean, you can't even get them along to a tribunal to give evidence, because I've tried to get the relevant decision maker along to the tribunal and said, this is essential for what we're talking about. And the tribunal said, oh, well, no, they've stopped working there, so that you can't do anything about it. So I think, sadly, the idea that you could ensure that they were at an ADR is remote. Yeah, I think no.
So the final question isn't a tax one, but do we know if the recording of this meeting or this will be available after? And I'm told that it will be. So anyone who wants to listen in again, you have that opportunity. But with that, I will say thank you very much for listening.